The Laundering, Case 09, Cross-Jurisdiction. 3 deaths, 3 provinces, 1 architecture. Open the case.
3 deaths in Canadian hospitals. 3 coroner's inquests. 3 different exits from the same architecture. Brian Sinclair, Anishinaabe, age 45, double amputee, died of a treatable bladder infection in the waiting room of the Winnipeg Health Sciences Centre Emergency Department in September 2008, after being ignored for 34 hours. Joyce Echaquan, Atikamek, age 37, mother of 7, died of pulmonary edema in the Centre Hospitalier de la Naudière in Joliette in September 2020, after live-streaming nurses calling her stupid and good for sex. Samuel Uko, age 20, born in what is now South Sudan, drowned in Wascana Lake in May 2020, within the hour after being forcibly removed from the Regina General Hospital Emergency Department.
And the 3 inquests.
3 coroner's inquests followed, each operated under a statutory mandate that excluded findings of liability or racism. Each exited the question of racism through a different procedural door. The architecture that received all 3 inquests is 1 architecture.
And the connection to the series.
Case 07 examined the federal architecture by which civilian oversight bodies process allegations of serious institutional misconduct by the military. Case 08 examined the provincial coroner's inquest as applied to a single death in a Regina hospital. Case 09 examines the architecture across 3 provinces. The vocabulary of placement, layering, integration from Case 01 carries over unchanged. The substrate, a coroner's inquest into the death of a racialized patient in a Canadian hospital, is constant. The mechanism, with consistent results, is 1. What varies between Manitoba, Quebec, and Saskatchewan is which procedural exit the architecture takes.
3 lives. Briefly, from the public record, this case examines what the inquest did with these deaths, not the deaths themselves.
Each substantive treatment is in its corresponding source. First, Winnipeg, September 19th to 21st, 2008. Brian Sinclair, Anishinaabe, age 45, double amputee, wheelchair user. On September 19, 2008, Brian Sinclair was sent from a community health centre to the Health Sciences Centre Emergency Department in Winnipeg to have a catheter changed. He spoke to a triage clerk on arrival. He was directed to wait. He waited in his wheelchair in the public waiting area of the emergency department for the next 34 hours.
And what happened during those hours?
The hospital's own video monitoring system captured many nurses, physicians, and other staff walking past Mr. Sinclair and looking directly into the waiting area where he was seated. Other patients alerted staff that he appeared unwell. He vomited on himself. He was assumed by staff, on multiple separate occasions, to be intoxicated, homeless, or sleeping. He was, in the scholarly formulation later proposed by Mary Jane McCallum and Adele Perry, simultaneously invisible and overly visible. Invisible as a patient, overly visible as a stereotype. Brian Sinclair died of complications from a treatable bladder infection. He was found, dead, in his wheelchair in the waiting room on September 21st, 2008, by another patient. He had been in the emergency department for 34 hours and had never been triaged. Second, Joliette, Quebec, September 28th, 2020. Joyce Echaquan, Atikamek of Manawan, age 37, mother of 7. On September 28, 2020, Joyce Echaquan was admitted to the Centre Hospitalier de la Naudière in Joliette, Quebec, with stomach pain. She had a known chronic heart condition. Medical staff assumed she was suffering from withdrawal, an assumption not supported by her medical history or her stated symptoms. As she lay dying, Ms. Echequan live-streamed herself on Facebook. The video, viewed widely across Quebec and Canada, captured a nurse and an orderly making racist and degrading remarks to her in French as she screamed in pain and called for help. They called her stupid. They told her she was only good for sex. They asked who was paying for her care. She died of pulmonary edema linked to her chronic heart condition shortly after recordings stopped.
And what the coroner said.
In Coroner Jehan Kamel's later finding, if it weren't for the video footage, it's a safe bet that this event would never have been brought to the public's attention. The video is the reason the case became a case. The treatment was not unusual. The documentation of it was.
Third,
Regina, May 21st, 2020. Samuel Uko. Born in what is now South Sudan, age 20, refugee to Canada in 2005. On May 21, 2020, Samuel Uko sought help at the Regina General Hospital Emergency Department twice in the same day. On the first visit, he told the screening nurse he was having depressing thoughts and suicidal ideation. He was diagnosed with depression, given a referral to a mental health clinic, and discharged. The standard of care escalation cascade for a verbal disclosure of suicidal ideation does not appear on the public record of his care. Hours later, in active crisis, he called 911. Regina police brought him to the same hospital. He was stuck between registration and triage. 4 security guards forcibly removed him from the building while he shouted that he had mental issues and needed help. Within the hour, his body was found in Wascana Lake. The forensic pathologist determined the cause of death as drowning. His family said it was suicide. The Saskatchewan coroner's jury called it drowning from undetermined circumstances. Samuel Uko's case is the subject of Case 08 of this series.
3 exits. What the inquest did with the question.
All 3 inquests were statutorily constrained to manner and cause of death, plus forward-looking recommendations. Each took a different path through that constraint. The Manitoba, Quebec, and Saskatchewan inquest regimes are not identical. The mandates, the powers, the appointing authorities, and the procedural rules differ in ways that matter at the margins. What they share is a structural property. None of them can find a hospital, a health authority, or a government liable. None of them can issue binding orders. None of them can compel implementation of their recommendations. What they can do is determine manner and cause of death, hear evidence at the discretion of the presiding judicial officer, and issue recommendations. Within those constraints, 3 coroner's inquests examined 3 structurally similar deaths and arrived at 3 structurally different documents.
The Sinclair Inquest, Manitoba, 2014.
Time elapsed from death to report, 6 years, 3 months, September 2008 to December 2014. Presiding officer, Judge Timothy Preston, sitting as coroner. Was racism within scope? Originally yes, then no. Judge Wyant in 2009 ruled racism, poverty, and disability would play a large role. Judge Preston in January 2014 ruled racism, poverty, disability, and substance abuse beyond the mandate. Did the inquest name systemic racism as a contributing factor? No. Phase 2, originally intended to consider Aboriginal experience in Manitoba healthcare, was reduced to one witness. The family walked out. Number of recommendations? 63, with just 5 hinting overtly at race. The Sinclair Working Group later concluded the recommendations wholly have not done anything to protect Indigenous people. 10 years later.
The Echaquan Inquest, Quebec, 2021.
Time elapsed, 1 year. Presiding officer, Coroner Jehan Kamel. Was racism within scope? Yes. Kamel examined evidence on racism in hospital treatment as an integral part of the inquest, including expert testimony on systemic racism. Did the inquest name systemic racism as a contributing factor? Yes, explicitly. Kamel's report. The racism and prejudice Ms. Echaquan faced contributed to her death. At press conference, asked if she would still be alive if she were white. I think so. Top recommendation that the government recognize the existence of systemic racism in its institutions. Political response. Premier François Legault refused. Quebec has maintained repeatedly that systemic racism does not exist in the province.
The Uco Inquest, Saskatchewan, 2022.
Time elapsed, 2 years. Presiding officer, inquest coroner Robert Kennedy. Was racism within scope? Not formally on the table. The Coroner's Act mandate did not contemplate findings on racism. The recommendations include institutionalized racism in training, but no finding on its role was made. Manner of death, drowning, undetermined circumstances. Number of recommendations, 20, covering training, staffing, layout, handoff, intake. Pre-inquest civil settlement? Yes. The Saskatchewan Health Authority admitted failure to meet the standard of care in a March 2021 Statement of Defense, $81,000 settlement paid. The inquest convened on top of an already resolved liability question.
The architecture. The same machine, 3 different procedural doors.
Manitoba preempted the question. Quebec named it and was refused. Saskatchewan distributed it across training. The architecture absorbs all 3.
Exit 1, Manitoba, 2014.
Rule the question out of scope. Phase 1 of the Sinclair inquest heard evidence on assumptions about Mr. Sinclair as Indigenous, homeless, and intoxicated. As Phase 1 drew to a close in January 2014, the presiding judge ruled that issues of race, racism, poverty, disability, and substance abuse were beyond the mandate of the inquest. Phase 2, which the family and Indigenous organizations had expected to address Aboriginal experience in Manitoba healthcare, was reduced to a single witness. The family walked out. The substantive question of racism never reached evidence. The 63 recommendations addressed waiting room procedure, triage protocols, and staffing. Substantially, the question of how to manage delays in an emergency department.
Exit 2, Quebec, 2021.
Name it. Let the political authority refuse. Coroner Jehan Kamel heard evidence on systemic racism as a contributing factor. Her report named it. Her top recommendation was for the Quebec government to acknowledge the existence of systemic racism in its institutions and commit to its elimination. Premier François Legault refused. He has continued to refuse. Quebec has also declined to accept Joyce's principle, drafted by the Atikamekw community in Ms. Echaquan's name. The architecture allowed the inquest's broad finding to be made, and absorbed the finding at the political layer above by simple declination.
Exit 3, Saskatchewan, 2022.
Distributed across forward training. The Saskatchewan inquest into Samuel Uco's death convened on top of an already resolved civil liability question. The Saskatchewan Health Authority had admitted failure to meet the standard of care in a March 2021 statement of defense and paid an $81,000 settlement. The inquest examined operational witnesses, not policy authors. Manner of death, undetermined circumstances. 20 recommendations clustered around future training, including on institutionalized racism, unconscious bias, microaggressions. The substantive question of whether racism contributed to Samuel Uko's death was distributed across an undifferentiated population of all future staff, to be addressed through training of those future staff. The death itself was never formally adjudicated as racism.
And what the three exits have in common.
In all three cases, the relevant institution, the Winnipeg Regional Health Authority, the Centre Hospitalier de Laundering, the Saskatchewan Health Authority, survived the inquest with its operational existence intact. In all three cases, the relevant province made formal commitments to implement recommendations. In all three cases, advocates have subsequently documented that the recommendations have not produced the systemic change the inquests gestured at. In all three cases, the family or community of the deceased remained, after the inquest, the primary external party calling for substantive accountability that the inquest could not provide. The laundering's central claim has, since Case 01, been that closed institutional cycles can produce reputational assets without examining the substantive question they were constituted in response to. The three inquests examined in this case demonstrate that the architecture has multiple available exits when the substantive question concerns the death of a racialized person at the hands of a Canadian institution.
Forcing functions. Why the three inquests differed.
None of the three exits was inevitable. Why each was taken matters. A common defense of the Canadian coroner's inquest system, made by working coroners and by sympathetic legal scholars, is that the statutory mandate genuinely constrains what an inquest can do. Coroners cannot find liability, they cannot issue binding orders. Their recommendations are advisory. The argument is that anyone expecting more is misunderstanding the system, and that the architecture is doing what it was designed to do.
And the three-province comparison tests that defense.
If the statutory mandate genuinely constrained the inquest, the three inquests would have arrived at similar outputs. They did not. Coroner Kamel, working under a Quebec mandate, named systemic racism. Judge Preston, working under a Manitoba mandate, ruled it out of scope. Inquest Coroner Kennedy, working under a Saskatchewan mandate, dispersed it into training recommendations. The variance is significant. The statutes are similar enough that the variance cannot be explained by statutory difference alone. The variance is, at least in significant part, discretionary within the statute.
What then explains the discretion?
A combination of forcing functions external to the inquest itself. First, public documentation at scale. Joyce Echequan's live stream made the racial character of her treatment unavoidable. The video was viewed across Canada. By the time the inquest convened, refusing to address racism was no longer a procedurally invisible option. Brian Sinclair was captured on hospital video being ignored, but the existence of the footage was internal and did not become public in the same forcing way. Second, family and community legal representation. The Sinclair family and Indigenous organizations were party to the inquest until Phase 2's narrowing, at which point they walked out. The Echequan family participated through the report. The Uko family attended, but did not have the kind of independent legal representation that could have moved for inclusion of the protocol question.
Third and fourth.
Third, pre-existing political pressure. Quebec's inquest convened in 2021 after a year of national mobilization around Indigenous deaths in Canadian healthcare, including the COVID-era reckoning that had brought in plain sight the 2020 BC report on Indigenous-specific racism in BC healthcare into public discourse. Manitoba's inquest convened in 2013 to 2014, before that wave of mobilization. Saskatchewan's inquest convened in 2022, when the pattern was visible, but local political will for a Quebec-style finding was not. Fourth, the disposition of the presiding officer. Coroners and judges have different histories with these questions, different reading lists, different relationships with Indigenous communities, different professional risks associated with making bold findings. Coroner Kamel's willingness to say on camera that Joyce Echequan would still be alive if she were white is not a procedural fact. It is a personal one. It mattered. Fifth, prior settlement. Where the civil liability question has been resolved before the inquest convenes, as in Saskatchewan, the inquest's incentive to examine the question is reduced. The institution has already paid. The family has already taken the settlement. The public proceeding is left with operational and training matters. If the variation between three inquests of similar facts is contingent on factors external to the inquest, then the architecture's processing of these questions is not law-like. It is responsive to forcing functions. Where the forcing functions are absent, the architecture's default mode is procedural narrowing. The implication for any future case is that the architecture will tend, in the absence of unusual external pressure, toward the Manitoba exit. It is the most procedurally compliant of the three. It is the most institutionally protective. It is the one the architecture takes when it is permitted to.
Prior work. This argument is not new.
The structural critique of the coroner's inquest as a mechanism for processing Indigenous deaths has been made before, most fully by the people best positioned to make it. This case stands on a substantial body of prior scholarship and advocacy. We acknowledge it here explicitly because much of the laundering's argument in this case was made first, more fully, and by people closer to the substance.
The Sinclair literature.
Mary Jane McCallum and Adele Perry, Structures of Indifference, An Indigenous Life and Death in a Canadian City, University of Manitoba Press, 2018. The canonical scholarly treatment of Brian Sinclair's death and the inquest that followed. The phrase, simultaneously invisible and overly visible, is theirs. So is the structural framing of the inquest as an instrument of Canadian state response to Indigenous death. The Brian Sinclair Working Group, Drs. Annette J. Brown, Mary Jane McCallum, Emily Hill, Barry Lavalley, José Lavoie, and Shireen Razak. Out of Sight, 2017. The principal expert response to the inquest's narrowing, with detailed analysis of the procedural decisions that excluded racism from consideration.
And Razak's foundational work.
Shireen Razak, Dying from Improvement, Inquests and Inquiries into Indigenous Deaths in Custody, University of Toronto Press, 2015. Foundational work on the structural function of the inquest as a state response to Indigenous death. The arguments in this case are downstream of Razak's framework.
And the Atikamekw in BC contributions.
The Atikamekw Community of Manawan, Joyce's Principle, drafted November 2020. A 16-page document calling for equitable access to health and social services for Indigenous people. The principle has been recognized by the federal government and some provinces, It has been declined by Quebec. The Government of British Columbia. In plain sight, addressing Indigenous-specific racism and discrimination in BC healthcare, by Mary Ellen Turpel-Lafond, 2020. Independent investigation commissioned by the BC government documenting Indigenous-specific racism in BC healthcare as a structural feature, not an aberration. The BC report's findings reframed the national conversation in the months immediately before the Echequan inquest convened.
And the case's contribution.
The Laundering's contribution in this case is not the structural critique of any single inquest. It is the comparative move, placing the three inquests alongside each other and asking what their variance tells us about the architecture as a whole. The comparative move only works because the underlying work on each case has been done, substantially, by the authors listed above. We refer readers, especially Indigenous readers, to those primary sources for the substantive treatment of the deaths examined here.
Close. What this case is and isn't.
This is not an accusation against any single nurse, physician, security guard, registration clerk, coroner, or judge named in the public record of any of the three inquests examined here. The conduct of named individuals is not the subject. The architecture is.
And the architecture.
The architecture is a Canadian institution that has, over 14 years, processed at least 3 deaths of racialized people in Canadian hospitals through coroner's inquests that arrived at no formal finding of institutional racism in Manitoba, or arrived at such a finding only to have it refused by the political authority above the inquest in Quebec, or arrived at training recommendations that distributed the question across an undifferentiated future staff in Saskatchewan. The 3 inquests on the available public record demonstrate that the architecture's default response, in the absence of external forcing functions sufficient to compel a different outcome, is procedural narrowing.
And the structural finding.
Each of the 3 inquests was, within its statutory mandate, defensible. Each presiding officer was qualified. Each jury was constituted. Each report was issued on time. Each set of recommendations is, within the form of recommendations, considered. None of these facts are in dispute, and none of them are the structural finding. The structural finding is that the form of recommendations is what the architecture has to offer, and that the form of recommendations does not contain the question of why these specific people died in these specific institutions at the hands of staff who, by the institution's own subsequent admissions, did not provide the care that was their obligation.
And the substantive question.
The substantive question of whether systemic racism in Canadian healthcare contributed to the deaths of Brian Sinclair, Joyce Echequan, and Samuel Uko is, on the public record, answered as follows. By Manitoba, no formal finding. By Quebec, yes, finding made, provincial government has declined to act on it. By Saskatchewan, no formal finding, question distributed forward into training. The substantive question has been examined in significant depth by the scholarly literature, by Indigenous-led advocacy, and in the Quebec case, by the inquest's own findings. The state record, the set of formal Canadian government documents that constitute what the country has officially said about why these people died, contains, on this question, less than the literature does, less than the families have said, less than the available evidence supports.
And what remains?
The architecture is in working order. It produces on time the documents that Canadian governments require it to produce. The next time a racialized person dies in a Canadian hospital under circumstances that suggest systemic factors contributed, the architecture will process that death. The exit it takes will depend on local conditions. The state record produced will be defensible within the form of inquest reports. The substantive question, whether the country tolerates the systemic conditions that contributed, will, on present evidence, remain a matter for the literature, the family, and the community, not for the state.
3 names.
Brian Sinclair waited 34 hours in a Winnipeg emergency department to be seen. Joyce Echaquan filmed herself dying while being mocked. Samuel Uko was carried out of a Regina emergency department by 4 security guards while saying he had mental issues. The architecture that processed their deaths is the architecture that will process the next. It is in working order. The question of whether it will be permitted to continue is a political question, not an inquest question. The literature has done its part. The families have done theirs. The communities have done theirs. What remains is for the architecture's funders, Canadian voters, Canadian taxpayers, Canadian governments, to determine whether the documents the architecture produces are documents they consider adequate.
Open call. Corrections and additions especially welcomed.
From Indigenous readers, from family members of any of the 3 subjects, from the Brian Sinclair Working Group, from clinicians and advocates with primary source access. If you have standing to correct or extend this case, we want to hear from you. This case is a comparative analysis written from outside the communities and families most affected by the deaths it examines. We have grounded it in the public record and in the published work of authors and advocacy groups closer to the substance. We accept the limits of that position. The series Standing Stance, Open for Correction, applies to this case with particular weight.
Who we want to hear from.
We are especially interested in corrections, additions, or contestations from members of the Sinclair family, the Echaquan family, and the Uko family, on any aspect of how this case has characterized your loved one's death or the proceedings that followed. Members of the Brian Sinclair Working Group and the authors of Out of Sight and Structures of Indifference. The Atikamekw community of Manawan and the authors of Joyce's Principle. Indigenous healthcare workers, hospital administrators, coroners, and judges with experience inside any of the 3 jurisdictions' inquest systems. Where corrections are warranted, they will be made and dated. Where contestations are made, they will be added to the public record of this case. The architecture's sole source monopoly on the documents that would settle these questions is, again, a structural feature of every case in the series. Closing that asymmetry is what an open record is for.